Good morning, everybody, and welcome to this AEI webinar on McCulloch versus Maryland at 200 in honor of a book recently published by AEI Press titled McCulloch versus Maryland at 200, Debating John Marshall's Jurisprudence. My name is Adam White. I'm a resident scholar here at AEI and, as it happens, a contributor to the book. This book project was created and edited by my colleague, Gary Schmitt, a resident scholar in strategic studies in American institutions here at AEI, where he also leads AEI's program on American citizenship. I'll introduce Gary in a moment, and he'll have some opening remarks. But we're also very lucky today to be joined by three scholars on the case at hand. And so let me briefly introduce them as well. Professor Jane Nodell is a professor of economics at the University of Vermont, where she writes and teaches on money and banking, macroeconomics, and economic history. Her writings include the 2017 book, The Second Bank of the U.S., Central Banker in an Era of Nation Building. She'll speak first, and then she'll be followed by Professor Robert Faulkner. He's a professor of political philosophy and American political and legal thought at Boston University. His many books include The Jurisprudence of John Marshall, and he co-edited the Liberty Fund's abridged edition of John Marshall's The Life of Washington. And last, we'll be joined by Professor Kevin Walsh. Professor Walsh is a professor of law at the University of Richmond, where he teaches and writes on the federal judicial power in our constitutional system. He's also president of the John Marshall Foundation, and he curated the National Constitution Center's exhibit on John Marshall. Those who follow our events know that he joined us last year for an event on the Chief Justices. We're glad to have him back. We're glad to be joined by all of our panelists and by you, the audience, as well. So with that, I'll turn it over to Gary Schmitt for some introductory remarks.
Thanks, Adam. Well, let me begin by thanking Bob, Kevin, Jane for joining Adam and me today. And I'd like to also thank AEI's Social, Cultural, and Constitutional Studies program for hosting this event. I thought I'd begin by sort of basic why the book, why we decided to commission the essays and then publish a book. Well, the basic reason, and not a surprising one, is that the belief that great Supreme Court cases inevitably raise important questions, not only about the law, not only about politics and policy issues, but about the political order itself. And frankly, I think McCulloch v. Maryland does all those things in spades. So back in 2019 in the spring, my former colleague and the co-editor of this volume, Rebecca Burgess, and I thought it would be appropriate to bring together scholars to commission essays, which eventually resulted in this volume. The book itself is composed of 6 chapters. There's an introduction by me and six substantive chapters, and an appendix consisting of Marshall's opinion. Now, 3 of the chapters analyze Marshall's opinion in pretty good detail. One by Nelson Lunn criticizes Marshall's opinion and its particulars. A second by Chris Wolf from the University of Dallas defends it as a model of pre-20th century constitutional jurisprudence. And then the third essay by Adam White argues that Marshall was likely engaged in an act of judicial statesmanship. There's a chapter by Michael Zuckert of Notre Dame University that covers a distinct argument about the necessary and proper clause by James Madison, which Madison raised when he was deliberating, but also arguing against the establishment of the First National Bank in 1791. Zuckert's point is that Madison has a middle way between a broader reading of necessary and proper by Alexander Hamilton and the very narrow reading by Thomas Jefferson. The next 5th chapter is by Robert Webb King of the University of Texas at El Paso, who writes on and analyzes Marshall's own defense of his opinion, which he wrote under the pseudonym A Friend of the Constitution. And then there's a 6th chapter that's authored by Abram Shulsky of the Hudson Institute, which talks about the bank itself, why it was thought necessary, its character as an institution, and also what it might mean for understanding the larger project when it comes to the American economy. And then my introduction is an attempt to give some background and context to both Marshall as Chief Justice and also the politics of the day. Now, as most of you know, that have tuned in, you probably already know this, the particular issue before the court was whether the state of Maryland could tax the federally chartered national bank. Chief Justice John Marshall, writing for the court, argued that the nature of the federal union precluded Maryland from doing so, and in turn argued that chartering the bank was within the implied powers of Congress. At least that's the Cliff Notes version of Marshall's take on our take on Marshall's opinion and his decision. But as I opened up with, there's a lot more going on here. Underlying the opinion are issues related to the nature of the union, principles for interpreting the Constitution, the reach of Congress, the place of precedents in constitutional interpretation, a delegation of power to public-private corporations, the character of the national economy, and I would argue even if indirectly, Congress's power to regulate slavery in the new states. So there is an immense amount, I think, going on in this opinion, in this issue. And again, it's the key reason why Rebecca Burgess and I thought it would be appropriate and useful to commission the essays and then publish this book. I'm looking very much forward to the discussion that follows. And Adam, turn it back to you.
Thanks, Gary. And I'll turn it over to Professor Nodell for some remarks on the economic background to the bank and the bank debate.
Great, thank you very much, Adam and Gary, and I'm very pleased to be included in this webinar. I believe I have a few slides. I'm someone who in my career as an economic historian has been fairly obsessed with the Second Bank of the United States to the point where I decided I needed to just write the book. So these slides are just going to review kind of the case for Marshall's ruling in favor of the Second Bank of the United States. Second Bank of the United States, okay. So really the question in many ways comes down to whether it's a monetary justification or whether it's a fiscal justification. So in Abram Schulsky's very interesting chapter, he notes that the relevant congressional power for forming both of the banks would have been, one would think, that of coining money and regulating the power thereof. That would seem the most obvious power to invoke, yet Marshall invokes really fiscal powers, namely the power that Congress has to lay and collect taxes, to borrow money, to raise and support armies and navies. But Schulsky points out that Marshall did not explain exactly how the banks of the United States facilitated the execution of these powers, much less one would argue whether it was necessary to have these national banks for the United States Congress to execute these powers. Next, please. My research really kind of aligns with Marshall's opinion. And I started out really thinking of the Second Bank as a real early central bank. And at the end of the day, I concluded that it really wasn't. First, if you look at why did Congress charter the Second Bank after letting the first bank's charter expire 5 years earlier, clearly, I think general agreement that the United States government came out of the War of 1812 in a very much weakened fiscal condition. It did manage to get through the war without a national bank, but it ended the war in very bad shape. In part, this was because of the monetary fragmentation in the country, meaning lots of different kinds of currencies with different values vis-a-vis specie or silver and gold coin that was the basis of the monetary system. And the lack of a national currency really put the government in a near default position in the sense that it had revenues collected in one region, and they could not be readily mobilized to service debt held in another region, much less converted into specie to service the debt held abroad, and there was considerable debt held abroad. The price of US debt fell dramatically over the course of the war, and the government was borrowing at pretty high interest rates, but at the end of the day, and only in very short-term notes, in fact, treasury notes, which were essentially a fiat currency. Next, please. When you look at the charter of the second bank, there are very explicit fiscal duties that were required of the second bank. You cannot find a lot of explicitly monetary duties. And those fiscal duties were that the second bank was to transfer federal government funds, from place to place within the United States or its territories, and distribute these funds without charging the US government any fees or any fees for exchange. And this was an increasingly challenging and costly enterprise, given the fact that the transportation network was not very well developed. This was before there were very many canals, much less roads kind of across much of the country. And there was a growing spatial difference between the places where revenue was being generated, that is US government revenue, which was primarily customs revenue, and places where the government was needing to spend money. And you see a rising share of the war and Indian departments throughout the period that the second bank operated. The second bank was not directed to create a national currency for all parties within the economy, just for the United States government. Next, please. The second bank's fiscal functions did pull it into monetary stabilization. And it did this mainly because the second bank used its branch network to become the dominant dealer within the United States in domestic and sterling bills of exchange. And these bills of exchange were used to finance trade, either within the United States or from US to the UK. And of course, cotton figured very prominently in that on the export side. And so the second bank basically used this branch network that it needed to build in any case to provide the fiscal functions. And then it generated a lot of revenue through these operations and bills of exchange, which helped make basically the economic or the business model of the bank work. So successfully balanced the duties that had to perform, which would have been very costly on their own, with the profits it did need to generate as a shareholder-owned bank. These bills of exchange operations also kept exchange rates within the specie points, which kept the nation's stock of specie at home and reduced the cost of servicing debt held abroad, US debt held abroad. Next, please. So specie figured very importantly in the economy, and the second bank became the single largest holder of specie in the banking system and in the US economy. And that gave it a lot of power and also responsibility. The specie worked as a buffer stock vis-a-vis the state banking system, that is the banks chartered by the state governments, and moderated expansions and contractions of the state banking system. But it's quite clear when you read the correspondence of the second bank between the second bank branch, the head office in Philadelphia and the cashiers running the different branches, that the second bank's management and board did not believe in having the second bank function as a lender of last resort. It really felt that the state banks needed to take care of themselves to make sure that they could maintain specie payments. So at the end of the day, I think that the real case for the bank, looking at it as an economic historian, were the fiscal services that it provided to the national government, and the monetary services were kind of a byproduct of those. Thank you very much.
Well, thank you, Professor Nodell. Next, we'll turn to Professor Faulkner for discussion of Chief Justice Marshall's role in the case. Professor, I think you're still muted. Let's try this one more time. Sorry about that. Nope, still muted. Can the tech team unmute Professor Faulkner? Professor Faulkner, maybe if, in the bottom left corner, there's the mute button. Maybe if you do it manually.
I did.
There we go. Thank you very much.
So what makes McCulloch versus Maryland worth debating 200 years later? Not the decision. The constitutional legitimacy of a national bank has been a dead issue for more than a century and was pretty well decided by precedent before the decision. It's, of course, the opinion, John Marshall's opinion for the court. For that is a great lesson, I think, rhetorical and substantive, in combining four crucial but clashing principles of the American constitutional project. I mean, effective government, federalism, limited government, and popular government. The lessons, broadly speaking, are these. Effective government is a government of sovereign powers. Federalism rests on federal supremacy. Limited government is especially through defined and separate powers. And popular government means especially representation through an original consent. One feature of the book we're considering today is genuine debate as to just how judicious, how statesmanlike was Marshall's combining of these elements. The first chapter, which is Nelson Lund's spirited chapter, is far from a eulogy. It's more a takedown. Marshall's is a destructive legacy, not a constructive one, and on a grand scale. According to Lund, the McCulloch opinion destroyed the constitutional limits on the legislature. It thus, according to Lund, destroyed the fundamental structure of constitutional government, wandering off into the theory of union by consent and evading hard questions as to the scope of Congress's power. Marshall, in fact, allows Congress unlimited latitude. But that argument overlooks Marshall's defense of the fundamental structural limit on all the government, its separation of powers. Christopher Wolf's fine chapter shows that. Congress has its own legitimate sphere, its political power. Courts are not to encroach on that sphere of policy, as we say, or as Marshall says, in language that actually is pregnant with limits on the degree of necessity of means for executing its enumerated powers. Now that antique language indicates real structural limits. Marshall is emphatic. There are judicially enforceable constitutional limits, even apart from explicit prohibitions. Congress has but enumerated powers, and the court will intervene should Congress exceed those. But this place is not the place to develop these, contrary to Lund. The danger Marshall confronts in McCulloch is virtually the opposite of congressional excess. It is rebellious states and states' rights theories that would narrow Congress's legitimate sovereignty and in effect endanger its sovereignty over conflicting state laws. Marshall's rhetorical emphasis is then on Congress's discretion, and the limits appear as but reassurances, subordinate to a fierce insistence on Congress's sovereignty and federal supremacy accordingly. Let the end be legitimate. Let the act be within the Constitution's scope. Let it be within its letter and spirit. And then all means plainly adapted to that end are constitutional. Robert Webking's chapter emphasizes this point. Congress's powers are limited to means to execute the enumerated powers. So limited government. But one must also add effective government. For as Marshall emphasizes, those enumerated powers are great powers, such as those to tax, to war, and to defend. Within that controversial sphere, Congress is entitled to all the discretion of a supreme sovereign. If chartering a corporation, a bank in particular, is genuinely a means to one or more of these powers, and not contrary to a prohibition, it is constitutional. Here, Shulsky's remarks are interesting. He notes the large political economic implications of this. The growth, for example, of corporate power, especially a corporate, big corporate power, the delegation of public policy. Michael Zucker presents a Madisonian alternative. Madison in 1791, a congressman, denied the constitutionality of Hamilton's proposed First National Bank. Zucker mentions two chief arguments. First, Madison distinguished sharply objects of union from objects of the government. Those enumerated powers of government may have been instituted as means to the union, but once instituted, they are themselves the ends to be executed. Execute those powers as given, not as what may be needed for the union. And secondly, Madison denied that government itself implied as such effective powers. Quote, no power not enumerated can be inferred from the general nature of government. So if the powers, you omitted the power to make treaties, for example, if the founders omitted the power to make treaties, for example, Congress can lament, but not correct. But really, can one understand governmental powers and objects of this country except in light of the union's power and objects? Marshall's theory of union by consent to government virtually identifies the two. And had not the framers intended to vest the government with powers commensurate to, quote, the exigencies of the union, unquote. So Marshall contends. I'm not sure how many times he mentions the word exigencies. And so Madison had himself suggested in Federalist 46. It must be said that Madison, as president, approved a charter for the Second National Bank, the very one at stake in McCulloch, although only after rejecting an earlier version. Marshall's understanding of the spirit of the Constitution was consistently more grand than that Madisonian alternative. It is a constitution we are considering, and the constitution of a nation, quote unquote, intended, quote unquote, for the ages. Yes, Congress's powers are but means to enumerated powers, but those are great powers needed for a sovereign nation. And as to means, Marshall does not encourage calculations too close or exclusionary. Quote, throughout this vast republic, from the St. Croix to the Gulf of Mexico, from the Atlantic to the Pacific, revenue is to be collected and expended, armies are to be marched and supported. Is that construction of the Constitution to be preferred that would render these operations difficult, hazardous, and expensive? There's a grand understanding of what effective government means, with limits thematic elsewhere, as in Marbury versus Madison, and for that matter, in Gibbons versus Ogden on the spirit, and therefore the intent of the Commerce Clause. Marshall remains a model, it seems to me, for justices struggling in alien times and views to preserve something of our constitutional persuasion and government. He is that rare bird, a judicial statesman. As Adam White suggests, he showed both the restraints of a judge subject to fundamental law and the restraints of a politic judge who makes needed views acceptable to his audience. Marshall shies away from arguments that would unnecessarily inflame his opponents. Still, the emphatic doctrine set forth in McCulloch versus Maryland did plenty of inflaming and exhibit more than restraint. They exhibit also powerful and combative rhetoric on behalf of the Constitution, the federal government, Congress's powers, and our kind of representative popular government. There is a spirited warrior within the author of that prose. Amidst the constraints of the law, Marshall's opinion shows the mix of careful deliberation and resolute action that characterized his own model statesman, Washington. In their deliberate ways, both were warrior statesmen devoted to introducing and then establishing the American project. Thank you.
Thank you, Professor Faulkner, and we'll finish with Professor Walsh.
All right. Thank you, Adam, and thank you to my co-panelists and to the American Enterprise Institute for sponsoring not only this event, but the book commemorating McCulloch at 200. And what's fascinating to me about this opinion is that there is still more to learn about this. And AEI for today has put together an interdisciplinary panel. I'm a law professor. I'm used to just talking to other law professors. I learned something when we hear from the perspective of economy, political philosophy, and the like. And so what I'd like to do in this sort of opening comments is situate some of the legal questions within the broader perspective and to think about an answer to Professor Faulkner's question of how do you address an opinion that is 200 years old. It is not just the opinion itself, but its reception history within the broader tradition of constitutional adjudication. And I suggest that the way to think about it is as a classic, something that is susceptible of multiple interpretations, multiple readings, and that the tradition that we carry on today is in part constituted by arguing about the significance of a classic like McCulloch versus Maryland. So in the traditional law professor way of addressing McCulloch, we talk about question one and question two. Question one is, did the Congress have the power to incorporate and create the Second Bank of the United States? So it's a question about the scope of congressional power. Whereas question two is about the limits on state power to tax, or you can flip it and say the federal government's power to create instrumentalities that operate in the states but are free from state regulation and state taxation. So I'm going to do something slightly heretical for the tradition of law professor treatment of this and suggest that those question one and question two are actually, in the grand sweep of the history of constitutional adjudication, are really third-tier questions when it comes to McCulloch versus Maryland. The first-tier question is really the nature of the Union. What is the nature of this government and of the political body of which the United States government is governing? So that's the first-tier question. What's the nature of the Union? And the second tier is, who has paramount authority to interpret the Constitution as law? So those, I think, are very, very important questions, in part because we're not really debating those anymore. We are debating the question of judicial supremacy, although Marshall, in this opinion, does not claim judicial supremacy. He does claim, in the very first paragraph, the authority for the Supreme Court to resolve important questions about the nature of state and federal power. I think once we understand these more fundamental questions, we understand a little bit more about why Marshall structured the opinion as he did. So he addresses, as I mentioned, interpretive authority right in paragraph number one, and he doesn't really argue for it. He just asserts it. And then this question about the nature of the Union, sometimes criticized by scholars for even addressing this. They say, why does this even matter? Well, Marshall recognized that the way to interpret the Constitution as law depended on what kind of legal instrument that it was. And the big debate over the nature of the Union and the nature of the Constitution is whether the Constitution and the government of which that it created, whether it's a sort of a compact, that is an agreement among the states. Because if something is a compact or a contract, you're going to interpret it differently than if it's something like a charter of government or what we might call a constitution. And so what he says is we must never forget that it is a constitution we're expounding. Now, this gets picked up in the tradition as suggesting that therefore you can read all sorts of stuff into it and it's got to be flexible and things like that. And Marshall does contrast a constitution with a statutory code, right? He says it can't have the prolixity of a statutory code, so it must mark the great outlines. But also, in calling it a constitution, he's rejecting compact theory. And he not only takes this claim about the nature of the Union in using it to answer the first question, that is the scope of congressional power, it also makes an appearance in question number 2, that is state power to tax, when he talks about the inability of a part, that is a state, to tax the creation of a whole. Okay, so I think situating these legal questions as third-tier questions helps illuminate some of the interpretive choices. I also think it helps us understand Marshall's judicial statesmanship. So in the volume, one of the essays, Professor Zuckert's essay, talks about Madison's approach to congressional power and his report and his arguments about the constitutionality of the bank. Interestingly enough, in the debates that followed McCulloch versus Maryland, which were most virulent theoretically in Virginia and practically in Ohio, most of those were, in fact, not centered on Madison's interpretation of congressional power. As has been mentioned, the first question was actually easy, at least the outcome. What the debates were really about was the nature of the Union and interpretive authority. So throughout the essay battles in the newspapers, right, when Marshall takes up his pen and writes anonymously to defend the opinion in McCulloch versus Maryland, he is answering the charges that rely not on Madison's report and his arguments about the bank, but on Madison's report in 1799 in response to the Alien and Sedition Acts, to the Virginia and Kentucky resolutions. And that is what Marshall is worried about. And we know this from his correspondence. He explains why he's doing this remarkable thing, right? And he knew he shouldn't be doing it. That's why he was operating under a pseudonym, and he took all sorts of steps to preserve his anonymity. But he explains to Bushrod Washington, his colleague and co-conspirator in this secret publication thing, that he's very worried that the Virginia General Assembly is going to pass resolutions condemning McCulloch similar to those that they passed in 1799. And so in this light, recognizing that these are the worries that Marshall has, we see how he kind of works his resolutions of the nature of the Union as well as the claim of paramount interpretive authority into the opinion. And it kind of leaves a puzzle at the end because the Second Bank of the United States died, right? It ended. And in part, that was, you had Andrew Jackson vetoing the recharter of the bank. And then you had states' rights theory that was ascendant, both practically and theoretically, really for the next few decades. And even today, then we have questions about the authority of the Supreme Court. And so as a closing suggestion for this opening remark, what I want to do is then take these observations about the significance of McCulloch and place Marshall in a place that we don't normally think about him. We think about him as simply as a Chief Justice. But in defining the nature of the Union, what I'd suggest is that he provides a bridge between the man whose biography he wrote, that is George Washington, and between the second most important president of the United States, Abraham Lincoln, in defining the nature of the Union. And Lincoln could not rely on Marshall, right? He was against the Supreme Court. Taney was an enemy. He was constantly trying to cabin Supreme Court authority. But when he talks about the nature of the Union in the Gettysburg Address, right, there's those closing lines where he talks about that government of the people, by the people, for the people shall not perish from this earth. Lincoln is drawing directly from Webster's second reply to Hayne in the Senate. And Webster, this was over the issue of nullification of the tariff in the 1830s. And in that, Webster was relying on McCulloch versus Maryland. And so here's a passage from the opinion that doesn't get a lot of attention when we dissect it just as sort of law professor kind of way. But this now is Marshall. It's not Webster and it's not Lincoln. He says, the government of the Union is emphatically and truly a government of the people. In form and substance, it emanates from them, its powers are granted by them and are to be exercised directly on them and for their benefit. Now, he wasn't the wordsmith that Lincoln was, but you can see right there in McCulloch versus Maryland a claim about the nature of the Union that falls apart after McCulloch versus Maryland and ultimately holds together in the famous case of Grant versus Lee. Thank you.
Well, thank you, Professor Walsh. I'm going to give everybody a chance to offer any reactions or follow-up they might have. But before I do, I just want to remind the audience that we'll be taking your questions as well. You can submit questions to be presented to the speakers in either of two ways. On Twitter, you can send questions to hashtag McCulloch versus Maryland. Sorry, try that again. McCulloch v. Maryland at 200. So McCulloch v. Maryland, the word at, and then the number 200. Or you can send them by email. You can send them by email to Nicole Penn. She runs our program on social, cultural, and constitutional studies. Her email address is Nicole, Nicole, .penn, Penn, at AEI.org, and we'll look forward to your questions. So as I mentioned, maybe we'll go in the order of the people first spoke, if there are any responses or reactions or follow-up. Gary?
Yeah, thanks. And thank you, everybody. These wonderful comments. I have a bunch of reactions, so it's hard to start. But I think one of the first things I was kind of struck by, and I have been struck by, is the degree to which, after the War of 1812, there was much more nationalism in the body politic in the US. I mean, so for example, there was much more of as Jane pointed out, concern about sort of tying the country together, roads, ease of taxes, and all the kinds of things that make you, a real government. At the same time, this, snake of the compact theory and states' rights resurrects itself, and it doesn't go away. And I do think Marshall's opinion really, primarily, as Kevin suggests, is really, and you see it in his essays when he's defending the opinion. It's really aimed at going after the compact theory as much as anything else. So I'm just kind of struck. I mean, the degree to which you have these two different movements in the body politic going on at the same time. I just wonder whether anybody has any comments about whether the one fed the other, or whether they're just the natural inclination of a federated, union.
Right. Professor Nodell, if you'd like to respond to that, or any other thoughts you wanted to add.
Sure, thank you. I'll have to give Gary's comment a minute or two, but I just wanted to note that, of course, Maryland, back to the issue of the states versus federal government, that there were many other states that were also, kind of taking their own assaults on the Bank of the United States. And some of them were much more aggressive than Maryland's. Maryland's was really just around raising revenue, because they had incurred a lot of expenses in the War of 1812. They had yet to be reimbursed by the federal government. They needed revenue. And they were just proposing to tax the Baltimore branch in the same way that they were taxing state chartered banks. Whereas other states were really trying to make it unprofitable for the bank to do business within their state borders. And I find it interesting that the bank obviously had lawyers, and they made a decision about which case to pursue, and they decided to go for the Marylands. And I was reading a book by Ellis. I think it's called, I got that, you probably know that, maybe Kevin, you know this book, Aggressive Nationalism, I think it's called. So I think he said there was a strategy to get it to the court as soon as possible, because the bank wanted to settle this as soon as possible. But you see that some of these states that were very against the bank, in the late 1810s. And of course, there was a bad panic of 1819, and the bank made some mistakes during that panic by insisting too rigorously on the state banks, kind of paying them on time and so forth. So the second bank really made the economic recessions much worse in some states than it needed to. But when you fast forward to the kind of the veto and the run up to the veto, many of those states in the West were where there was a lot of support for the second bank, including from the state bankers. And so they kind of saw the benefits in terms of the lowered cost of accessing markets, which had broad benefits to the people that were living in their communities that were trying and working hard to create farms that were going to support themselves and their families. So I just think it's kind of I just wanted to kind of add that to the mix. Thank you.
Fascinating. Thank you. Professor Faulkner, do you have anything further to add?
Not to that. I would just say that Marshall deeply feared Jeffersonian states' rights theory. He does not comment in the case elsewhere much upon the slavery issue. And his opinions, actually, his judicial opinions as to slavery are quite moderate. But the importance of a powerful central government is great. And I think it's wonderful the way that Kevin mentioned also the idealism of his account, that ours is a popular government and the influence of that teaching. But these two matters, devotion to the country and a fear of the Jeffersonian states' rights theory, are very important to him.
Professor Walsh.
Guess maybe trying to tie these strands together. One thought maybe, given these competing strains that Gary mentioned, the nationalism on the one hand and states' rights on the other, we think, what tools did the Chief Justice have at his disposal to advance the idea of the Union and of the federal government? And this is where the nitty-gritty of federal jurisdiction becomes really, really interesting. So Maryland, as Jane mentioned, they needed revenue. That's why they were taxing the bank. They weren't like Ohio trying to drive the bank out. Ohio really wanted to get rid of the bank. Virginia, the power structure in Virginia was profiting from the bank. Spencer Roane, who wrote some of the essays, he was buying stock for his nephew in the bank right around the time of oral argument. And so Maryland, though, they agreed to this case, and this is something people recognize. What people don't often recognize is the nature of this agreement. So this case itself was about a penalty for not putting a stamp on 5 banknotes. And there was a $500 tax for each of those. And you just think, if you're a lawyer in 1818 structuring a case, why would you do that? Well, the reason you would do that is, at the time, there was a belief, and I think it was correct, that there was a $2,000 amount in controversy requirement that was incorporated into the Judiciary Act of Section 25, which was the jurisdictional provision from this other provision of the Judiciary Act. But Marshall took advantage of this sort of case that was served up to him in order then to make some pretty broad interpretive claims. Not, Adam, as you say, he exercised restraint with respect to the deference to Congress and deference to political branches. And as Christopher Wolfe points out, on the degree of necessity and things like that. But he makes these broad claims. And then when the storm really hits, it's 5 years later in the case of Osborne versus Bank of the United States from Ohio. And the interesting thing he does there is he actually addresses Ohio's objections and its refusal to accept McCulloch as a precedent. He does not claim the sort of modern version of judicial supremacy. He says, we thought about it more and we were right. But he doesn't treat Ohio's rejection of the authority of the decision as lawless. He just says it's wrong. And so Marshall, I would suggest, responded to these strains through really statesman-like exercises of jurisdiction.
Yeah. If I could just offer one small reaction of my own, and it's in part response to Professor Nadel's presentation, thinking about the immediate historic events preceding the litigation, right? The War of 1812 and the practical challenges that the nation faced in the War of 1812 in the absence of the bank. That immediate and deeply felt historic experience, I think, really fills in the gaps of some of Marshall's opinions. When the case is taught today or debated today, so often there's criticism of Marshall's opinion for not really applying his necessary and proper standard to the actual bank. I think I debated this a little bit with Nelson Lund when Nelson and Gary and I did an AEI podcast on the book and on the case. And the point that I made there, which I sort of allude to in my chapter, but maybe in the second edition, Gary, I'll make it a little bit more explicit, is that Marshall was able to write the opinion without saying too much because it was all well known. People knew precisely how the country suffered by not having the bank during the war. So these sort of broad generalizations where he talks about the St. Croix to the Gulf of Mexico and the Atlantic to the Pacific, that wasn't an abstraction. That was the war effort that they had just faced from Quebec to Florida and from east to west. And so one of the virtues of Marshall's opinion then is that it really is rooted in the factual experience of the country, and it wasn't just sort of abstractions. So I would throw that out there. But maybe moving from historic precedents to legal precedents, I want to get back to a point that Professor Faulkner mentioned. He said, by the time the case arrived at the court, the legal issues were already basically settled by precedent. Am I understanding you correctly, Professor? And if so, would you maybe elaborate that point a little bit?
Well, I'm really repeating what Marshall himself says, that the constitutionality had been debated and more or less accepted. Even Madison, for heaven's sake, justified his final acceptance in part because of the common history of precedent and such. I meant no more than that.
Okay. I don't know if anybody else would like to weigh in on that as well.
Let me add.
Oh, please go ahead, Professor. Continue.
Let me add. Marshall turns from the question of precedent to discuss the question of whether, if the issue came up anew, how would it be decided? He reaches out to state his answers in principle and therefore his rhetoric about the principles, which I think is in part his aim in the case.
And on this point about the sort of the legal question being settled, there was a really fascinating article a couple of years ago by Professor Will Bode of Chicago. He wrote in the Stanford Law Review about Madison's view of constitutional liquidation, the theme of Federalist 37, and sort of its bookend with Madison's treatment of the bank question. And so I'd encourage people to consider that. Gary, were you about to jump in?
Yeah, I was just going to say the next edition will be, McCulloch v. Maryland at 300. So if we're around, so I'll invite everybody to participate. No, what I've been struck by is, first of all, the issue wasn't settled. So you have the first bank, you have Republican objections to it. You have a grudging acceptance by Madison, which I'll get back to. And then, of course, Jackson objects to it constitutionally, and that's accepted. And Story writes, well, if this isn't, a settled matter, then nothing is. And of course, he's writing when it wasn't a settled matter. So it's an interesting issue in sort of, the character of precedent and its weight. But I wanted to tie something together. I hadn't thought about it until Professor Nadell, raised it, which is just the different character of the first bank from the second bank and the logic behind it. And I'd like to tie that to Madison's grudging acceptance, which is, acceptance of the bank at sort of a lower common denominator of what the bank was supposed to do. Instead of Hamilton's grand plan for kind of a Bank of England that would, have both monetary and fiscal responsibilities and would be the driving force. And I just wondered, and this goes to Adam's essay, one wonders whether or not one reason why Marshall is somewhat reluctant to sort of tie some of these things together in his opinion isn't if he thinks, I finally have a segment of the Republican establishment on my side when it comes to these national powers, and I don't want to push the envelope anymore. In other words, I'm not going to argue about internal improvements. I'm not going to talk about coins and the like. So I wonder if there's kind of a judicial statesmanship here that just is practical politics, which is Marshall believes that he can make the case, he can keep the principle, but do it in a way that doesn't disturb the politics of the day.
Professor Walsh, the other aspect of this we haven't talked quite as much about is the aspect of the state's taxing power versus the federal government's own powers. Could you explore that a little bit?
Sure. I think so to your earlier question about was this all settled, I think on the question one answer, that is the power to create the bank, not all the foundational principles were settled, but the outcome was. That was not a closed question anymore, and in part it was because of precedent, in part it was because Madison himself signed the bank in, all of that. On the tax question, which you asked about, something that Marshall does not mention, but is pointed out by Ohio. So Ohio, this is not as well known, has a joint committee report on McCulloch versus Maryland. It ends up in the Annals of Congress for folks who are looking for it. It's 37 Annals of Congress, 1695. And one of the arguments that they make there is, hey, guess what? The first bank of the United States, they were taxed by Georgia. They ended up acquiescing in the tax. They sued in federal court to get their money back. It ended up at the Supreme Court on an issue unrelated to the tax itself, but Georgia ended up paying the tax. Now, what's so fascinating about that is, given that background, what Ohio says is if Congress wanted to create this instrumentality and make it free from tax, it could have done so, but it didn't. That is, it did not explicitly provide for immunity. And so we talk about Marshall's implication, his implied powers analysis in the question one, but question two is really implication upon implication, right? Once we've implied the power to create, then you imply an immunity from taxation. And I think what's happening there is a dodge of the really hard issue, because once you have implied immunity from state tax, that is a takeaway of a power that was concurrent. That is a taxing power. And so you have the ability under the supremacy clause to sort of take away a state power. So I thought that was a much harder question. And it's not at all obvious that the sort of implication of that immunity was correct under the law of the time. It's pretty well settled now.
Professor Nadel, if I could return to you for a moment, maybe we talk a little bit about what follows after the case. After all, again, your book is titled The Second Bank of the United States, Central Banker in an Era of Nation Building. And that era didn't end with the case McCulloch versus Maryland. If anything, McCulloch versus Maryland helped put further wind in the sails. We know what follows with the American system of Clay and Webster and the rest. I was wondering if maybe you could just explain to our audience a little bit what course this decision charted for the country moving forward and how it might have affected these issues that, as we mentioned, were on the periphery of this case: internal improvements, slavery, and so on.
So yes, I mean, from the early 20s, the second bank under Nicholas Biddle, second bank had a couple of pretty weak presidents, and it was kind of a miracle that it survived, really, to, through that panic of 1819 under the kind of fairly weak leadership that it had. But Nicholas Biddle, I think, was really a brilliant central banker, a bad politician, but a brilliant central banker. And just parenthetically on, why did the bank die in a way? I mean, I think that under a president with better political skills, the second bank might have survived. But Nicholas Biddle really took the fight right to Andrew Jackson. I mean, he was he made some mistakes. He was very politically active, and I think in an inappropriately so. And it just, in a way, I think, I'm not a fan of Andrew Jackson, but I think in many respects he was correct that the bank had taken too much power, especially when it tried to manipulate the political decisions around its future. But I think that on balance, as an economist, you got to look back and say that the bank performed an essential function in terms of really creating a national economy, tying together the different regions of the nation into an economy that would become quite powerful and would have a very good growth record in the 19th century, even though they didn't have a central bank. So after the demise of the second bank, I think that we did okay, right? And in large parts because I would argue that the state banks kind of copied many of the kind of financing techniques and that the second bank had shown them how to do. So they started to deal in the bills of exchange, and now there's all this debate among historians about how Jackson was kind of a good guy from a monetary point of view because he brought back real money, coins, instead of this nasty paper money that the banks were creating that you couldn't really trust. So, I mean, the debate about the second bank ended, but the debate about money, continued throughout the 19th century. And even beyond. I mean, you still have people today, questioning whether we should have a Federal Reserve, which is also very powerful outside in an instrumentality of the federal government in many regards. So in terms of the slave debate, I'm not exactly sure where. Can you say a little bit more about what you're thinking there with your question, Adam?
Well, this might be a question for which Professors Faulkner and Walsh might have some thoughts as well. This question of the reaffirmance of national power, of the union's power to govern. Obviously, the case was carried out in sort of the shadow of those debates, the slavery question and the internal improvements question. And so I'm just kind of curious what, if any, effect this opinion might have had on those subsequent developments and debates, even as Marshall sort of sidestepped those questions in his opinion. As I mentioned in my chapter in the book, there were plenty of advocates for the banks, for the federal government's power in the case, who were drawing direct lines in their arguments from the need for federal power here to those other questions. And then one of the points of my chapter is that Marshall sort of sidesteps, I think prudently sidesteps, those ramifications. But of course, there were ramifications on those issues. And so I don't know if Robert or Kevin have any thoughts on this as well.
Just as a historical point, the House had passed a resolution about the same time, which would effectively ban slavery or the growth of slavery in Missouri if it was to come in as a new state. And then the Senate rejected that. So that this is going on at the same time that the case is going on. But Kevin and Bob probably know more than I do about this.
And maybe I'd expand the question a little bit and say, obviously, this is just one, important part of Marshall's jurisprudence, but obviously, it's part of a broader sort of. It's part of Marshall's jurisprudence as a whole, and we've already drawn some connections between this and other cases. But I'm curious if Kevin or Bob have any just sort of general thoughts on how we should situate this within Marshall's jurisprudence as a whole. Was this completely consistent with the rest of his jurisprudence? Did this signal where he was headed in future cases, or were there any ways in which this was a sort of a break from what he had written elsewhere? Sometimes law professors try to hold this case in contrast with Marbury versus Madison, but perhaps it's not.
Well, maybe I'll jump in here so that Dr. Faulkner can have the last word on this. So slavery was, of course, in the background, and when Tawney essentially breaks the Supreme Court with the Dred Scott case, a lot of that has to do with the denial of congressional power over slavery in the territories. And so what Marshall says about Congress's implied powers is, of course, going to be important for that question of slavery in regulation of slavery in the territories. In terms of the broad sweep of Marshall's jurisprudence, we're most familiar with the sort of Marburys and the McCullochs and the Gibbons versus Ogden, right? Not all of Marshall's opinions were these grand expositions, but McCulloch is significant because it is one of those grand expositions, a kind of saying a lot. And you see the same thing in Gibbons versus Ogden a few years later, probably the most popular opinion of the Marshall Court, saying a lot. And he explains that the reason he is laying out all of these things, connecting A to B to C to D, fundamental principles to outcomes in cases, is precisely because those connections need to be made clear if the union is to endure and if the federal government is to be an effectual government as intended. And so I'd say it's characteristic of Marshall, that strand of Marshall, that is the constitutional exposition and the sort of thing that ends up in Joseph Story's commentaries on the Constitution in 1833, which were the kind of systematic exposition of sort of Marshallian, Hamiltonian, Washingtonian constitutionalism, doing battle explicitly with the Jeffersonians.
That Gibbons opinion, if I remember correctly, Marshall even phrases it in terms of, I apologize if some of these things, if I'm saying things that are already obvious, but they need to be said here, I think for precisely the reason you described. Professor Faulkner, do you have any thoughts on situating this and Marshall's jurisprudence as a whole? Obviously, you've already touched on that some in your remarks.
I think I've touched enough. This is characteristic of his jurisprudence as a whole, and he's very much involved with the success of this great popular experiment that the Americans have done, and that his idol Washington was especially responsible for.
Well, we do have some questions from the audience, so we'll turn to those. And just a reminder, if anybody else would like to submit questions, you can do it either on Twitter at hashtag McCulloch v. Maryland @200 or by email to nicole.penn@aei.org. The first question is this. It comes from Phil Hoxie. It's been suggested that Madison's changes to the bank led to its abuse by the wealthy class. Do you think there's a relationship between the expansion of the bank's branches and the rise of political interests created by the bank? I don't know who would like to take that first. I don't know if Professor Nodell, do you have thoughts on that?
Sure, I'll take a stab at it, and then I think maybe others can add. The changes that Madison made to the bank, not sure what that refers to, but obviously the bank did establish a very expansive branch network. And I've tried to understand how did it decide where to put these branches. And it was largely two factors in my view. One is they tended to go where there were fewer state banks. And they tended to go where there was a need to fulfill these fiscal functions. And, a lot of those were in the underbanked areas. So a lot of their branches were in underbanked areas. Now, the downside of that is that then they had a lot of monopoly power in those areas, and presumably the members of the boards of those branches also had a lot of economic and political power. However, the head office at Philadelphia, during the Biddle regime, very much was monitoring what those branches were doing. And they were very much under the leadership of Philadelphia. That was a strong central headquarters. And they were intended to resist local elites' efforts to gain access to credit from the bank that they maybe did not really qualify for. So the bank only wanted to lend. It was a very elite bank. It lent to the best credits. And it's getting some people kind of criticize it for that. But they were those, I don't think, maybe there's much I don't know about the branches. From what I saw, I didn't see a lot of them being captured by local elites.
Go ahead, Kevin.
I was just going to say on Mark Killenbeck has a book from the University of Kansas Press on McCulloch versus Maryland. One of his arguments is that Madison sort of the fateful choice early on was to appoint William Jones as the president. And William Jones had this vision of the second bank as more to be operated for its private stockholders, right, who owned 80% and controlled 80% of the votes anyhow. And that Jones, and this sort of attitude of, hey, we're also here for the stockholders and not simply for the fiscal operations, right? That it was a little bit more aggressive, and that it was the Baltimore branch where McCulloch was the cashier that had a lot of self-dealing and sort of resisted oversight in different ways. And so it may be less of a sort of Madisonian sort of what is the bank for than the kind of appointment of a president and delegation, right? And you could think of this as a delegation case, right? To the extent that the bank is making policy of different kinds, you have a delegation to a largely private corporation, and therefore who the president is matters. And Jones was not as savvy as Biddle, in terms of his leadership. And so you could think of this opinion as in some ways shoring up the bank, while at the same time you have hearings, or just almost coextensive with hearings on sort of the shenanigans in Baltimore and some of the self-dealing that was going on.
More generally on the political impact of the bank, one of our colleagues here at AEI, Jay Cost, in the last few months has published a couple of essays looking back at the political ramifications of the bank. I had Jay on my podcast here at AEI. It's called Unprecedented. We had him on the podcast in the last few weeks. We explored some of these themes. And Jay's point was that the bank as a whole, setting aside just the specific question about branches, but the bank as a whole, its creation created political constituencies, which in Cost's opinion then threatened to deform the political environment surrounding the bank. He wrote that this is one thing that Madison was worried about, and Jay writes it largely came true. And he compares that to much more recent political events where the creation of a new federal program or a federal administrative agency or so on can suddenly take on its own gravitational pull surrounding that. So I'd encourage people to look up Jay Cost's essays and maybe the podcast. Professor Faulkner, the next audience question is for you. It comes from Elaine Allen, and she writes, how did Marshall's bold warrior statesman approach, as you described it, in his McCulloch opinion, manage to avoid widespread popular backlash? Are there lessons here for today's justices who must sometimes issue unsavory and unpopular opinions? I'd add to that, it's widely said that Chief Justice Roberts is particularly mindful of the examples of his predecessors, and especially Chief Justice Marshall, and it seems to have affected his jurisprudence. But how should we understand how Marshall himself grappled with the political environment surrounding his opinions?
What struck me in rereading after many years McCulloch versus Maryland was the combativeness of it. And I mentioned, and I think Adam is absolutely right, he did not want to inflame enemies or friends for that matter, but especially enemies. But in fighting for crucial principles, his rhetoric was very powerful. The power to tax is the power to destroy. It's rightly said that, of course, is not necessarily the case. But in seeking to confirm the national authority and the extensive powers, the discretion of Congress, his language becomes in fact powerful and combative, and that my point was not that restraint is not called for. On the contrary, the court requires that. It's not a great political or populist body, but that sometimes fierceness is called for in defending very important principles.
If Gary, Kevin, or Jane have any thoughts on that as well?
Well, I mean, the opinion actually did generate quite a bit of pushback. I mean, it was, you know, so much so that Marshall himself thought he had to do an extensive defense of it. But I think there were kind of two audiences. I think Professor Faulkner's right. There's this big issue, the nature of the union, that he's really taking aim at. At the same time, I also take it that he's writing it in such a way as to ensure that he keeps on board that faction of the Republican Democrats, Madison and Gallatin, on board his project by not overstating some of the implications that you point out, Adam, in your essay. So,
I don't know if Jane or Kevin have anything to add on those. We have a few minutes. We have just a few minutes left, and we have one last question. Maybe we'll end with this. The question comes from J.R. Roach. He asks, "Why should we want our judges to be statesmen? Does the idea of statesmanship privilege prudential concerns over legal ones?" Obviously, that's the subject of my chapter. Maybe I'll let others, before I skew the conversation with my own views. I'd love to hear what others think about the role of the Chief Justice here as a statesman and how that fits with the Chief Justice's role as a judge. Gary, maybe we'll begin with you, actually.
well, I think I've made it, you know, pretty clear. I don't think a Chief Justice can escape the prudential considerations. That doesn't mean he has to, you know, toss his principles aside, but he does have to take into consideration context, because the principles to survive are going to be pushed back through the political system. So, you know, I think there is room for judicial statesmanship, and I think Marshall, in a number of cases, starting with Marbury versus Madison, exhibits that. Keeps the principle, but doesn't push it in such a way as to lose the fight outside the court.
Professor Faulkner?
This is such an interesting question. It's quite true that a judge, in fact, is to observe the law and is subject to the law. But our fundamental law governs our government. It's inevitable. It's a political law, not just an ordinary law. Therefore, interpreting requires not only political skills, but a certain political wisdom. And it's inevitable then that something like statesmanship enter in. Of course, it differs depending on the judge's position. Marshall was, in a way, a founder. He was a founder not of the Constitution, but of our constitutional law. And from that, therefore, the needs of his position were to some extent exceptional. But something like this, you mentioned Chief Justice Roberts, something like this occurs in all very major cases, although not at such a depth.
Professor Walsh?
The challenge here is to try and understand just what judicial statesmanship is. So Kent Neumeyer sort of put Marshall's project pretty well. He said Marshall identified himself with the court. He identified the court with the Constitution, and he identified the Constitution with the people. And each of those identifications, I think, is necessary for understanding judicial statesmanship. So the court is an institution. It's not as powerful or as persuasive as one person may be. It is a multi-member body. Marshall instituted the opinion for the court. You might think of that as an exercise of judicial statesmanship. That is a submerging of his individuality into the court for the purpose of sort of infusing the court's opinions with institutional authority. And where I think judicial statesmanship or invocations of prudence end up being criticized, and sometimes fairly so, is when the judicial statesmanship is accomplished by means that can't fairly be traced to legal considerations. Now, those legal considerations might include justiciability, right? So we may say, and we see this in McCulloch, we define certain questions as not judicial questions. But once something is a judicial question, it has to be legal. And the challenge is to be able to explain your outcome and your with legal reasons. And one of the things that's sort of endearing in some ways about Marshall in his response to the critics, particularly in Virginia and in Ohio, is that he doesn't respond by saying, well, I've got the votes. Right? He doesn't respond by saying, we have the jurisdiction. He responds by offering his arguments and by tying things to first principles. And the reason you may say that's endearing is it didn't work. Right, that is states' right. I mean, it's not as if people read his responses to Amphictyon and Hamden and said, "That's it, I'm convinced. You're right about the nature of the union." But he did it anyway, and so I think the nature of Marshall's judicial statesmanship is something that we ought to try to study. It's very hard to encapsulate, but as Bob mentioned, it's inescapable. To have a prudential dimension to these things and have a need for practical wisdom in the application of the law.
I see we're up against time, so I would just add, since my chapter was focused specifically on statesmanship, that so often judicial statesmanship is described in terms of judges going beyond sort of the mere bounds of law, and that the heroic judicial statesman is the one who sort of transcends that role. My description of statesmanship, borrowed from Professor Harvey Mansfield's study of Burke and Burkean statesmanship, was that statesmanship could be described in terms of saying less than you can, right? Offering justifications, but not saying more than you need to in order to address the problem. I also point out that Tocqueville, in his study of America, says that of judges, there needs to be statesmen in them. And so this notion of judicial statesmanship goes back to Marshall's own time. And it's the challenge then is to think about what it means in our own. Now, if people are interested in that, they can read my chapter in the book. And speaking of the book, maybe we'll end with this. Gary, what should people know about the book's publication?
Yeah, let me do a commercial at the end here. The book, because of the pandemic, was supposed to be out already, but it will be out in early September, and you can go to Amazon or to Rowman and Littlefield and pre-order the book. So please don't wait for the Netflix series of the book. Go get the book. So let me, before Adam finishes, let me thank my panelists for a great day and great presentations. Thanks.
Great. Thank you, Professors Nodell, Faulkner, and Walsh for joining us. And thanks to our audience for joining us today. Please stay tuned to AEI's website for other events that we are hosting online when we can't be together. And please join us again next time.